to some extent Wyoming, but I guess if I were asked to identify the 3 states I think are most active in these areas, it's probably Nevada, Alaska, and Delaware. But site selection, as I call it, is a key component of your plan, and there'll be much more discussion about that later. So initial step, you come in, you meet with a lawyer, you talk about what are your circumstances, what are your objectives. The next step will occur to a great extent outside your presence, meaning the lawyer is going to sit down and think about what your objectives are and how to achieve those. The lawyer will have in mind the tools available to him, which we'll go over in a minute. He'll think about the potential sites where he can locate these entities that may form a part of your plan, and decide what is the sort of complete system that will be most helpful to you. And then once they run that past you, which is sort of phase 3, that's a third meeting in which you discuss what your options are. Ultimately, you make the final decision. The lawyer can only make recommendations. Those will be guided to some extent by your circumstance. I mean, some of you can afford a very elaborate, expensive plan that might include offshore planning and exotic things such as that. That could be easily the risk of sticker shock here. That could easily be $25,000 plus to do that sort of planning. Not a lot of people opt for that unless they have the sort of assets in which that percentage investment is but a very, very small component of what's involved. And for those people, sure, that would be what the discussion might entail. But for many others, it's something much less. It may be simply choosing the sort of corporate forms that they want. It may be some estate planning tools. It may be some contracts. It could be a variety of things. But site selection will probably be a component of the plan. But again, that third meeting, or that third step rather, second meeting, would be one where the attorney gives you more specificity regarding what he or she thinks is the best plan, and you have to decide whether or not you want to endorse it, whether you choose to opt for part of it, or how you want to proceed, if at all. And then whatever decision is made at that stage, the fourth and final stage is the implementation process. And we'll talk more about that, much more about that as we go along. And I'm going to use a sort of model that I think is helpful in describing what we're doing here. And I hope it works. If it doesn't work, you can imagine another metaphor. But I find that it's helpful to think of this as building a structure, building a sort of fortress that is capable of withstanding the attacks from others, whether they're creditors or whether they're predators. These are people who want your wealth. And so you develop a structure, this fortress that you think will withstand those assaults. Well, as in any construction process, there's an early stage. And in those early stages of the construction process, what do you do first? Well, you go through the plan design stage, and we talked about that. It's the initial meeting, it's review of the documents, it's development of a plan that makes sense. And the site selection usually takes place as a component of that. It might be that the site is moved. Incidentally, that doesn't have to be in stone. Sometimes an initial place will be chosen. Sometimes people choose to incorporate or to create entities in their own state. Then subsequently they decide that they want to transfer those entities. Those things can be done, but under some circumstances it doesn't make sense. So you need to anticipate whether or not you're going to likely be moving later, or you're wanting the home of your entities to move later. Let's talk a little bit about the asset protection toolbox. Entity options. You can choose a number of entities, meaning corporations, partnerships, limited partnerships, family limited partnerships. There are several ways you can go in terms of deciding what tool best suits your circumstances. We'll talk about the entities first. When you think about entities in asset protection, really you're probably talking about either a corporation, a limited liability company, limited partnership of some sort. Could be an LLP, limited liability partnership is what they're called in some states. And then a family limited partnership. Generally, a protective entity that's formed will probably be in one of those four forms. And we'll talk a lot more about that later and why some generally make more sense than others. I didn't mention a general partnership there because generally speaking those are just not useful. The rules regarding general partnerships apply to both partners fully as to joint and several liability, and that's generally not where you want to go if you're doing asset protection. So it's very unusual to use a general partnership for asset protection purposes. So that was entities. Transfers of title. Simple concept. We talked about this a little bit in the previous show. It simply means that in some cases it makes sense to transfer title to property from your name to someone else's. You have to be careful. It can't be a fraudulent conveyance. We'll talk a lot about fraudulent conveyances on this show. But it can't be that. But it is perfectly permissible without these illegal purposes to transfer assets to others. Now it can trigger things. It will have income tax implications. It will have gift tax implications potentially, and potentially estate tax implications. So these are things that can come into play, but anyone who does a substantial amount of asset protection planning can deal with these, and often they're not a problem if they're handled correctly. There's a number of ways to sidestep any tax problems in that transfer. So transfers of title, what it does though, when you have one person that is in substantial risk, say in a marriage for example, one party who's at substantial risk and the other party who's not, or you have an individual outside of marriage who's at substantial risk and someone else is not. Again, there's a lot of trust involved in these transfers, and as divorce lawyers, we're not very trusting in terms of transfers of assets to others. So I bring a very skeptical, cynical view to that particular technique. But I've been doing this long enough to know that for many people they're quite comfortable with that. And there are marriages that are very solid where you have a doctor who's at risk and a homemaker who's not, in a state where tenancy by the entirety is not helpful. So there are circumstances where it might make sense for that doctor to transfer assets to his wife. They're out of his name completely. So if someone sues him individually, they're not going to, generally speaking, be able to get to those assets. Now, you want to be sure and have the wife not participating in his business. There are a number of caveats with that, but that's just an example of how you might use a transfer of title. But again, you have to bring the perspective of a divorce lawyer to this, which of course Cordell and Cordell does, and you want to consider all the ramifications of that transfer because there is some risk involved in that. Contracts. This is a very broad subject, but the reality is that you can deal with lots of risks with contracts. It's done all the time. A contract is simply a written agreement where you anticipate problems and you deal with them in advance. You may have a liquidated damages clause, meaning if this happens, I agree that the extent of my liability will be X, will be $1,000, or I agree that neither party will be able to sue the other if such and such happens. Now, there are certain types of contracts that are considered contrary to public policy. You can't enter into those contracts in some employee relationships. You can't enter into those in relationships that are inherently risky, where it's considered just contrary to the best interest of the parties involved, or at least one of them. So there are limitations to using contracts, but they're used all the time. And a good example of where contracts are used to limit risk is in prenuptial agreements. In a prenuptial agreement, it's simply a matter of the parties sitting down and saying in advance of the marriage that in the event of divorce, this is the way the assets will be divided. Throughout the marriage, even in the absence of divorce, a prenuptial agreement can provide for how assets will be owned and what their ultimate disposition will be when one and both parties die. So those can form a very important function apart from expecting or anticipating divorce. And then a more limited tool, but a very powerful tool when it applies, is a postnuptial agreement. Postnuptial agreements are ones where the parties are married and they decide thereafter that they want to enter into a deal by which they divide their property, or they make decisions about how those assets will be conveyed at death, who will inherit what. It's not uncommon when you have people who are married and they have children from prior relationships. They may have different anticipated estate planning objectives. So in those scenarios, a postnuptial agreement can be very useful between the parties. Now, let me hurry to add that these are subject to the review of a divorce court in the event that there's a divorce. So you need to have lawyers involved on both sides of the table for those to be effective. And it can't be grossly disadvantageous to one side of the table over the other, or most courts in most states can set it aside if they think that it's unreasonable or it's unconscionable. That's an example of how a contract can be used, though, and there are many others. Trust, we'll talk a whole lot about trust, and matter of fact, the next show I think we'll dedicate entirely to that particular option. The reason I want to spend a lot of time talking about trust is that in many cases it's the cornerstone of the estate planning process. Trust can form the foundation